What would be the difference if Puerto Rico were a state in your argument?
I think as far as this argument would be concerned, there would not be a difference.
How would the Congress be able to adopt or enact PROMESA and apply it to a state in this manner?
There may be a difference in the source of authority that Congress would rely on. It wouldn't be Article 4, of course, but the Congress has the power to abrogate in appropriate circumstances as long as it has that power, and the same rule would apply if clear and unmistakable statement of intent to abrogate.
Just one final question: would you? I know your preference is to assume immunity, but would you, since I prefer not to assume immunity, would you tease out a bit your basis for a territory having sovereign immunity, and with respect to the applying sovereign immunity in courts, are those federal courts, for example, a superior court, or is it a territorial court or one of the local courts?
Sure. So our position is that the sovereign immunity of a territory is part of a large body, a large doctrine of constitutional common law or common law sovereign immunity. It goes by different names. The idea behind it is that once Congress gives certain attributes of sovereignty through an organic act, for example, to a territory, then the common law basically dictates that as a result of the sovereignty that it has at that point, it's entitled to immunity both in its own courts and in federal court. There are two different strands, though, which I want to emphasize, both of which are associated with sovereign immunity, but they're important. The rationales are slightly different. One of them is the principle that a sovereign cannot be hailed into a court without consenting to being held that way. That principle would mean that Puerto Rico could not be sued without its consent in federal court. But there's a second strand, which I think is even more powerful here, which is that a sovereign as a lawmaker, part of this sovereignty or the aspect of being a lawmaker is the power and the autonomy to decide who the law applies to. If Puerto Rico passes a territorial law, Puerto Rico is able to decide that that law should not apply to it. On CPI's theory, if that sovereignty only applies in territorial court, what that would mean would be, as could happen here, Puerto Rico could pass a law, and in federal court, Puerto Rico could be sued under that very law. That would be a serious invasion of Puerto Rico's sovereignty and autonomy to hold it responsible that way.